India, the world's largest democracy, has been on a complex and long journey towards recognizing the rights and dignity of its LGBTQIA+ community. In a much-awaited verdict today, a 5-judge bench of the Supreme Court rejected petitions seeking same-sex marriage in India and refused to tweak the Special Marriage Act. On May 11 this year, a constitution bench led by Chief Justice of India D.Y. Chandrachud with Justices Sanjay Kishan Kaul, S. Ravindra Bhatt, Hima Kohli and P.S. Narasimha concluded a 10-day hearing and reserved its decision on the pleas for legalizing same-sex marriage. The petitioners had urged the court to apply the Special Marriage Act 1954 to the LGBTQIA+ community, arguing that only marriage can provide the relationship with legal status. In stark contrast, the Indian government criticized the pursuit of equality, branding it as urban elitist views. Their stance was clear. Parliament, not the courts, should decide this matter. The courtroom during 10 intense days got into the debate of semantics, even exploring alternatives like contract or partnership to describe same-sex unions. 5 months on, the Supreme Court made a verdict today. Refusing to grant legal recognition to same-sex marriages, it emphasized that the power to legalize same-sex marriages lies with the legislature. CJI, while announcing the verdict, rejected the BJP-led centre's view that queerness is an urban or elite concept. CJ Chandrachud emphasized that homosexuality or queerness is not an urban concept or restricted to the upper classes of society. The verdict refused to strike down the Special Marriage Act and Foreign Marriage Act for not recognizing queer marriages. Instead, it recorded the centre's statement to constitute a community to examine the rights and benefits that can be extended to queer people. While CJ Chandrachud and Justice Sanjay Kishan Kaul asserted that queer couples should be given adoption rights, Justice Ravindra Bhatt, Hima Kohli and P.S. Narasimha disagreed. The ruling highlights the considerable road that lies ahead for the LGBTQ+ rights in the country. For over a century, Section 377 of the Indian Penal Code criminalized homosexuality, threatening up to 10 years in jail for engaging in same-sex relations. In 2001, the NAS Foundation launched a legal challenge claiming this law violated India's constitutional rights to freedom from discrimination. In a 2009 groundbreaking decision, the Delhi High Court ruled in favor of decriminalizing homosexuality, making India's first step towards LGBTQ+ equality. This ruling emphasized fundamental rights like privacy, fair treatment, and prohibition of discrimination under the Constitution. However, a setback occurred in 2013 when the Supreme Court reversed this decision, demanding legislative action. It was only in 2018 that the LGBTQ+ community rejoiced in SC's decision, where it decriminalized Section 377. While 2018 ignited hope for the community, 5 years later, India remains reluctant to fully embrace the rainbow of pride. The struggle continues and the call for equal rights and recognition remains as resonant as ever, reminding us that there is still much work to be done in the quest for full acceptance and inclusion. The rejection of the notion that queerness is confined to urban or elite circles is a powerful message that seeks to debunk stereotypes and broaden understanding. However, the question that arises is whether the LGBTQ community should settle for this level of progress. Is it enough to consider this a victory, or is it a case of advancement marred by hesitation? I'm Deepthi Rao and you are watching India Today SoSouth.